Welcome to Oil and Gas Law with Energy Law Prof. Today we're going to talk about constructive production savings clauses, and we're going to start with the example of the shut-in royalty clause. So you'll remember we talked about how to maintain the lease through the primary term where you're exploring for oil through paying delay rentals. And then we talked about what kind of oil and gas production you need, whether in paying quantities or otherwise, to maintain the lease during that secondary term as long as oil and gas is produced. Today we're going to start talking about constructive production. Constructive production is things that the lease defines as production even if there's not literal production ongoing. So some examples of constructive production savings clauses. The first one we'll talk about today, shut-in royalty clause. So where you have a natural gas well, there's not yet a market for natural gas available, so you shut in that well and you pay an often nominal payment annually to the lessor or the landowner to maintain that lease. We'll also talk about a dry hole operations or cessation of production clause, which basically says, hey, look, I'm working on it. I'm working towards oil and gas production. So even though there's no literal production happening on the lease yet, I should be able to keep it. Another kind of clause that we'll talk about is how pooling and unitization clauses can maintain the lease, because you might be, even though you don't have production on the land, pooled with some land where there is a well, and that well is being shared with a landowner, and so that means that though there's no literal production, there's still production allocated to the lease, and that will maintain the lease as well. We'll also talk about force majeure clauses, which is the situation where something usually outside the contemplation of the parties happens and prevents production for a little while, and so that can extend the lease as well. So these are all things that can be construed as production. Although they're not literal production, under the terms of the lease, they count as production. All right, so first example, shut-in royalty. That's what we're talking about in this lesson. So that says that the lease remains in effect if there is a well on the property that's capable of producing oil and gas. We'll talk about that in a second. And it's shut in, and a sum is paid to the lessor. Typically, that sum to the lessor, to the landowner, is annual, like a delay rental. In fact, it's often the same amount as the delay rental, which can be a pretty nominal amount. So it may not be a lot of money. If you're particularly worried that your oil and gas company doesn't have an incentive to find gas quickly enough for a well that it's shut in, you might want to negotiate for a higher shut-in royalty so that there's a little bit of a larger payment to the oil and gas from the oil and gas company to the lessor if they are shutting in the well while they wait for a market. Okay, we're going to talk about this first case, Freeman versus Magnolia. It's from Texas. It's from 1943, and it's on page 248 in your book. In this case, the lessor received shut-in royalties late. So they weren't paid on time annually as they should be, and so the lessor says, therefore, the lease expires. Kind of like you remember from the delay rental context. You pay your rentals late, and then the lease is going to expire if you have an unless clause. Now the lessee, the oil and gas company, says, wait a second, two things. One, under the lease, it says that covenants aren't conditions. Okay, what do they mean by that? Well, let's go back to a previous lesson where we distinguish between an or clause where you just make a promise that if you don't drill, you'll pay money. So it's just a covenant. It's a promise to pay. And an unless clause, which was a condition on the continuation of the lease. So if you didn't pay, the lease ended. So the lessor here says, look, this is a condition. When you didn't pay the royalties on time, the lease expired. The lessee, the oil and gas company, says, no, our lease specifically says that covenants aren't conditions and that breaches can be excused. Okay, this is an interesting case because here you start to see a pattern that we'll sometimes see in the Texas cases and the Texas courts going forward, which is that sometimes maybe the parties were trying to say one thing, but the courts will at times follow their literal words, whatever they may have been trying to say. So here's what the court says. It says, let's look at the lease. The lease says, while the royalty is so paid, the well shall be held to be a producing well. So as long as the royalty is properly paid, that shut-in royalty paid on time in the right manner, then the well shall be held as a producing well. Does that sound like a covenant? It's just a promise to pay money if the well is shut in. Or does that sound like a condition on the continuance of the lease? Well, the Texas Supreme Court says that sounds like a condition because it's saying that the well is really only producing within the meaning of the lease if the royalty is so paid, properly paid. So because it wasn't paid in that way, the condition is not met and the lease expired. Okay. But what about the lessee's argument here, which is the lease itself says that covenants shouldn't be read as conditions. And maybe by including that provision, the lessee, the oil and gas company, was trying to say, you know what? Give us a little leeway if we forget to make a payment right on time. Because note that the consequences here are quite severe. They're actually even worse than in the delay rental case. Because remember, if you don't make a delay rental payment on time and your lease ends, that's really bad. But also remember that the majority of leases never have any oil and gas production because the majority of oil and gas wells for the whole scope of history, and if you go back for the early decades of production, didn't necessarily have production. Even if they had a well, only 1 in 7 wells for years would hit oil. And so although you lost that lottery ticket, you may have paid a lot for it in terms of the bonus, at the end of the day, the lease that you lost because you didn't pay the delay rentals may or may not have had oil. If you have a shut-in royalty and you forget to make a payment and that ends the lease, that's a very harsh result because the shut-in royalty payment meant that you had a well that was already capable of production on the lease. And so when you lose that, that's pretty catastrophic for a single late payment. And so when the lessee put this provision in the lease, covenants shouldn't be read as conditions. Maybe they meant, look, if there are these conditions, we should get some leeway to meet them. But what the court says is, well, maybe you meant that, but you didn't say it literally. So this will go a little bit LSAT game on you. But just because covenants aren't conditions, that doesn't mean that conditions are all covenants. It doesn't magically transform the conditions that you've written into your lease to become covenants. And what's in this lease is a condition, not a covenant. So the Supreme Court says, hey, you had no problem. If you had written a covenant in this lease, we promise we would not have read it as a condition. But what you wrote in the lease was a condition because you said, while the royalty is paid, the well shall be held to be a producing well. The royalty wasn't paid, the well wasn't producing, therefore, and as a result, the lease ended. Okay, here's an example, shut-in royalty clause, paragraph 3. While there is a gas well on this lease, but the gas is not being sold or used, the lessee shall pay at the end of each yearly period during which such gas is not sold or used as royalty an amount equal to the delay rental provided for, and while said royalty is so paid or tendered, this lease shall be held as a producing lease. So again, you can see that this shut-in royalty clause makes continuance of the lease dependent on the royalty being so paid. All right. So what's the effect of an improper shut-in payment? In Oklahoma, the lease continues as long as the well is capable of production. And you remember that from the Pack case, as it's also in this Guard versus Kaiser case, which is that in Oklahoma, the background rule is if you have a well capable of production, that's going to be sufficient to maintain the lease. So not a problem. In some states, it's set by statute. So in Louisiana, the lease will continue pending written notice. So if the lessee oil and gas company fails to make a shut-in royalty payment, you need to notify them as the lessor, and if they don't respond to that in time, then the lease may be dissolved. So in Texas, everything depends on the wording of the lease. So if, as in the example provision I gave you, and as in the Magnolia case that we looked at, the constructive production defined by the lease is proper payment, or the royalty is so paid, Then if it's not so paid or there's not proper payment, the lease will terminate. On the other hand, if the lease says that the lease will continue as long as there's a shut-in well, then the lease continues regardless of whether the payment was made on time. So if you want to write it so that it does not depend on the proper payment, then you just want to say that as long as there's a shut-in well that is capable of production, the lease will continue. And you can include an additional covenant or promise to pay a shut-in royalty, and then they can just sue you for that shut-in royalty, but the lease won't end because the lease is written so that it will continue as long as there is a shut-in well. All right, so as we've talked about, the well that is shut in has to be capable of production, or at least it traditionally has. Let's see how fracking is actually complicating matters a little bit. So historically, that well that you shut in had to be capable of producing in paying quantities for you to be able to rely on the shut-in clause. Here's the challenge. What about with fracking? Because with fracking, remember, first you drill that well, but then you fracture it and you put a huge amount of pressure down that well. And so that well is immediately then, as the oil and gas is released, going to want to flow back out. So it doesn't make a lot of sense to put all that pressure down and then shut it in for years. So the problem is that well really capable of production if you haven't yet released the oil and gas in it? So for that reason, a lot of modern leases included a fracking provision that says a well which has been drilled and the lessee intends to fracture stimulate shall be deemed a well capable of producing in paying quantities, and the date that that well is shut in shall be when the drilling operations are completed. So as long as you've drilled that full well and lateral, you don't have to actually fracture it to shut it in. You can wait to fracture it until you're ready to produce because there's a market for natural gas. Now, there are some things that you want to look at carefully in that lease term. So one thing, and you saw it in the example provision I gave you, is what if the lease says that you can only shut in a gas well? What does that mean, right? Is it a well that's only producing gas? Is it a well that's labeled a gas well by the Texas Railroad Commission or other Oil and Gas Conservation Commission? And you can have other provisions that say producing gas only. And notice how both of those provisions potentially put you in a difficult situation if you have a well that's producing some oil but a lot of gas and there's no market yet for the gas. Maybe you'd like to shut in that well until you have a market for the gas as well as the oil. Because if there's no market for the gas, you may have to just flare off that gas. There can be environmental regulations that prohibit you from doing that. There may be penalties for doing that. It can sometimes make you look bad as a corporate citizen that you're just flaring off all that natural gas. But if your lease term doesn't allow you to shut in a well that's producing some oil, you may be forced to either produce it and just flare off all that gas or just give up the lease entirely. And so for that reason, you want to watch for those provisions that say shut-in is only for gas wells, or especially if it says for wells that are producing gas only. Okay, you also want to look for a term that says that you're only allowed to shut in if there's no market available. Now, that's not so bad if it's like a question of just complete access to the market or not, but there can be circumstances where, yes, there's a market, but it's not a very good market, and if you waited a little bit longer, you'd get a much better price. And so those where there is no market available terms can make things difficult for an oil and gas company that's facing a not great market when it thinks that there'll be a much better market available later.